and this permission,
Yes.
sanction may be at a particular stage mandated.
Sanction is
In a particular stage,
collected.
it may be mandated, depending upon the language of the approval.
Yes. But when
Because want of sanction has its own consequence.
one more thing that I must submit is this: supposing the Lordships hold that the judgment is prospective and not retrospective, the operational judgment is prospective and not retrospective, then what would happen, my Lord? Would it require the government to give approval under 6A?
Post
Supposing they say we want to the police wants to conduct investigation today, and a lordships hold that the judgment is prospective, then such holding would require the government to give an approval under 6A, which is declared to be invalid.
there may be other practical difficulties also. Suppose during the course of investigation, this judgment had come.
Yes.
Then, in terms, they may not have taken approval. Neither they would have laid evidence with regard to the approval under 6A.
Yes. That's all right. Okay. This is all that I have to submit, my Lord. May I leave, my Lord? I am required in the court.
Anybody has to say anything?
I want to make a brief submission. Yeah,
You know,
very substantial issues,
you can-
and I want to
May I leave, my Lord?
I want to make certain submissions.
You have to say anything, Mr. Datta?
Just 4 points I want to say, just very short one. Just 1, 2, 3, 4.
Just wait. Yes.
So you'd like to mention something about the
May I just, my learned friend allows me, but then I'm teaching in another form. May I just few minutes that I
Yes.
First thing is, I think in these matters, what fell from your lordships in the morning is something that we should clearly bear in mind. The issue with your lordship was in many ways a very narrow issue. The question is only about whether the judgment of Subramanian Swamy should be made applicable prospectively or not. And your lordship, I think, in many ways rightly told me that even the 197 issue should not be argued, though there are many complexities of 197 in the context of conflicting judgment, but that's something which doesn't arise. My learned friend just now has opened up issues which have some very, very serious implications. There is entire body of law which has not been placed with your lordships on which should have been placed. And I don't think that it is appropriate that your lordship should expand the scope to go into these questions on inquiry. What is the inquiry?
Please stop on that. What he is saying is, when the question
Consequence.
when the question of immunity is there, while deciding the question of immunity, please bear in mind that the ratio of these judgments.
I don't disagree.
Therefore, he's not expanded in that way.
It's expanded in sense because a lot of the concepts on inquiry, which he says really doesn't apply in the context of 6A. Please bear in mind, 6A came into the statute in 2003. 6A was not there when all these other judgments were rendered from the time of Rishwood in the 1950s. The principle of 6A was really a safeguard to the commencement of an inquiry or an investigation. It is nothing more than that. And that safeguard, we may call it a sanction, we may call it a permission, we may call it a consent. But the underlying principle for that was essentially that even to commence an investigation against a public servant causes harassment to the public servant. And therefore, somebody within the government will make an assessment of the allegation and then determine whether this is a fit case to expose that public servant to an inquiry or an investigation. Because otherwise, as the learned SG rightly pointed out, that policy paralysis is something. We want to see it. I must say, having also dealt with cases of these matters, over the years, in many matters, there has been a policy paralysis. The concept of public servant is not the concept of a government servant. We see the definition of public servant be expanded. Panchayats, cooperative societies, all kinds of people of public, those who discharge public duties. The impact of this to limit it has some very serious ramifications because the definition of public servant under the 88 Act has been expanded from the 1940 from the IPC, section 21. So the trend and the legislative intent has been to keep granting some level of protection so that public servants can continue to act fearlessly in the discharge of their duties. Therefore, when a complaint comes from a citizen, whether that complaint is a matter to be investigated or inquired into because it otherwise impacts the public servant in the discharge of his duties, is a matter which the government or the appropriate authority has to take care of. And that is the reason why in 1969 we had the single directive for which was wrong. Then in 2003 we have the 6A and now we have the 17A. So all that it does is at a much lower threshold, not like a sanction where after collection of evidence, the removing authority has to apply its mind to the material and decide whether a public servant should actually face a proceeding in court. The threshold is lower because you are dealing with the question of suspicion.
Decide what.
But the question that arises,
Mr. Raju also said that in case there is a violation of statutory provision, the person has the right to move to the trial court or even the high court.
that's correct. Example, Bhajan Lal considered a case under the Prevention of Corruption Act. What happened in Bhajan Lal while saying out the illustrations is that they said that if there is a statutory bar, it's a ground for quashing of the FIR. 5A under the old Prevention of Corruption Act was violated. What was 5A? 5A was to say that an officer of a certain designation or rank will investigate the case. Your option said that 5A is violated. Reinvestigate and recollect the evidence. Why is it that the legislature has said that a public servant investigation should be ordinarily done by a senior officer and not by a junior police officer? That is one level of further protection to a public servant who understands the discharge of the duties and is responsible. Why is it that the legislature says that Prevention of Corruption Act cases should be tried by session judges? That's senior experienced judges. The legislative intent is that all that 6-8 days was to give that added level of protection or safeguard. Your lordship is saying it's a protection. It's a safeguard for public servant in the discharge of all his duties. And since the appropriate authority understands the nature of the allegation which is being made, the citizens may make all kinds
Mr.
of
Desai, this argument has limited significance. His answer to his submissions of complete immunity. That was the only point he made.
all I'm saying is that only really, if your lordship were to, as I said, I don't know how your lordship is trying to do it, but in the morning your lordship have a view. If all that is there is that the question of 6A is upheld because there is a lot of law surrounding all this. What is the legal implication? Evidence collected, is it valid, invalid?
Morning, I said we will not go beyond.
That's all I'm suggesting because if your lordship sees, I think it is only because one is opening up so many different dimensions of criminal law which will not be possible to deal with and the implications of all that because my learned friend is probably anticipating something else that may happen out of this this observation. I think there is a body of law starting from Bridgewood which in many ways deals with the implications of all that. Over the years, the lordships have dealt with it. The question is today, should your lordship sitting in 5 judges without having the perspectives of all this, once again start dealing with these aspects, and my humble submission to your lordship be that we should not expand the scope because otherwise we don't know where we are landing ourselves. As your lordship says, of course, it's very good for the bar because we'll be sitting and arguing on it. But I must say, your lordship, just as an example, in state of West Bengal versus Ghosh talked about 53 as the only provision under which 20 comes in. Actually, penalty has been a lordship have now determined the scope of penalty in a series of
That
that one has its own ramifications and implications, whether that's right, wrong, in some context.
We confine ourselves to what is before us.
Therefore, I am beginning to point out later on only one judgment which I think will facilitate what is falling from your lordship and what your lordship desires to do, because there is a direct judgment in the context of criminal matters. If I may take a minute of your lordship's time, or you may do it immediately after.
Immediately after.
immediately. I'm